Arrested for DUI and feel like there's nothing you can do? Well, in this video, we're going to give you 5 more ways the right attorney can fight a drunk driving arrest. Number 1, breath test machine calibration errors. So the breath test machine in Indiana has to be inspected every 180 days, and there has to be certain basically checks before the breath test is administered to the suspect. Now, we're not talking about the side of the road breathalyzer. We're talking about the main show down at the station, the ECIR2. And so this is a complicated machine. It's not a very good machine, but it's a complicated machine. And how they're supposed to do it is to administer Indiana Administrative Code. There's certain steps you have to follow. And I kid you not, officers make mistakes. The mistakes are so prevalent, the breath testing rooms in Indianapolis actually have giant poster boards on how to do it correctly. Officers still make mistakes. But the law is very clear. If the machine is not administered in the exact way it's supposed to, the results are out. There's no wiggle room. I've done the appellate case on that. There's no wiggle room. Number 2, a rising BAC defense. Now, this can get complicated, but don't overthink it. Essentially, when someone drinks alcohol, they're either rising or they're falling. So at the beginning of the night, when you have 1 beer, 2 beer, 3 beer, you're rising. After, midnight, when you've stopped drinking, or 10 o'clock, or like me, after you've had your dessert at dinner, you stop drinking, you're falling. And so if you take 2 tests about a half hour apart, it's very easy to figure out if a person is rising or they're falling. But Indiana doesn't do that. Now, a state will be like, we do take 2 tests. There's 2 breath tests within about 3 minutes of each other at the station, but there's not true 2 independent tests. So we don't know if people are on that curve going up or if they're on the curve going down. This can be a big issue when there's close calls. Someone's at 0.083, 0.09, or if someone's hurt, something crazy is happening, 0.15 on the nose, 0.153, because we want to try to get it under that 0.15. We want to try to get it under that 0.08. And so there are ways to do that with a rising BAC defense. And we essentially say, hey, when they stopped, they were lower than when they blew at the station. So if you stop somebody at 8 o'clock and they don't blow at the breathalyzer until 8:30, well, that's 30 more minutes for alcohol to absorb into their system. And it's likely, scientifically likely, that they were lower when they actually drove the vehicle. And Indiana has rebuttable presumption about intoxication, meaning that we get to argue that and we get to fight that. And that is something that get complicated, but the right attorney is going to have scientific training on that, such as the attorneys of the Marc Lopez law firm. Number 3. Now, this one is kind of cool, but basically the video evidence or the way a person's acting contradicts the objective evidence. And so we see that somebody passes field sobriety test, but they did smell like alcohol, there was a traffic violation, they get them down to the station and they blow a very high number, or their blood comes back with a very high number. Well, they look sober, they're talking sober, and this number indicates they should not be looking sober or talking sober. Basically, it doesn't match. And people don't like when things don't match. Now, the state of Indiana gets to argue, well, they're a hardcore alcoholic. They have a lot of tolerance. There's no evidence of that. So watch out for basically the numbers don't match what's on the video, or even if there is no video, the person's passing 2 out of the 3 field sobriety tests. Or they're passing the eye test, which is said to be the most reliable, but they're failing the other ones. And then there is some sort of a high number because that doesn't match. And when things don't match, in my world, that's a not guilt. Number 4, certain defenses such as necessity apply in drunk driving cases. And the best example is that through a story. I had a client that went to the bar with his friend and they actually called an Uber on their Uber app. And they went out to the parking lot to wait for the Uber and they heard gunshots about 5 feet away inside the bar. These guys ran to the car and he drove. Officers swarmed the area. They pulled over my client who was driving from the bar, and the officers thought perhaps he was involved in a shooting. And you know what? My guy was drunk as a skunk. But you know what? Not guilty, because we were able to argue necessity. And basically necessity is the crime you do is less harmful to society than the crime that was there. So this guy could have gotten shot, hurt, murdered. He drove. It's only about 1.5 miles from his house, and he got pulled over, and he actually was going under the speed limit, which is why the officer said he stopped him. So certain defenses do apply in drunk driving cases. Don't let your attorney say otherwise. Number 5, another way that we have won cases here is by showing chain of custody issues. Chain of custody is complicated, and there's not that many reported cases for chain of custody and DUIs, but sometimes there are such glaring errors that judges are like, wait a second, I can't figure out what happened next, and we're pointing it out. If you can't trust it, judge, you shouldn't use it to convict somebody. Now, chain of custody typically happens when there's a blood test, And what we frequently see is officer takes the blood. If it's state police, they drop it into basically a mailbox. Or if it's IMPD or local police departments, they'll take it to their forensics department and they drop it into a different mailbox. And then some days later, somebody grabs it out of the mailbox, out of the refrigerator where it gets eventually, and they test it. And the test results come back some point later and they get reported. And so you see these weird days and times. And sometimes things don't match. Sometimes people get a little bit sloppy. Now, I'm not telling you this is very often, but we have one case here at this law firm arguing blood chain of custody equals unreliability. And unreliability should never be used to convict somebody. So again, even if you feel like your DUI case is the most hopeless thing in the world, guess what? I've probably seen worse, and we've gotten better outcomes. If you have any questions about DUI cases, give us a call, 317-632-3642. We will talk about DUI all day. It is a passion of every single lawyer at this law firm. But most importantly, remember to always plead the fifth.